Good morning, everyone. We're delighted to see everyone back. We hope that you enjoyed yesterday's program and listened to Drew Dudley, our keynote speaker, Dr. Pat Bamba, discussing the most, and all the other presenters. And I hope that you found them informative, re-energizing, relevant, and engaging, and that you are able to share some of the information that you've learned with your colleagues, as well as apply it to your own work. I'm Erica Berman. I'm a member of the Conference Planning Committee who helped to coordinate the Guardianship Training Symposium for this year's event. I know that we wanted to have this in person, but unfortunately things did not turn out that way, but I think it's turning out okay right now, and that we will also have some recordings and slide and information to share with you later on after the conference is over. I also serve as the director of the Corporate Guardianship Program, which is operated by the ARC New York, and it's my distinct pleasure to welcome and thank you all again for joining us today. I will be addressing just a few housekeeping matters before we hear from the next three esteemed speakers in session 5 and 6. As we requested yesterday, please be sure to enter your name and where you are from in the chat box in order to document your attendance so that we can network with one another. And this needs only to be done once for the morning's program. Thank you. Please be sure to keep your microphones muted to help avoid any background noise. The different sessions throughout the conference have been recorded, as I said earlier, and will be maintained in our secure YouTube account. And we will be sharing again those links and the supplemental materials perhaps next week. And you can use it, we refer to it for future reference. We will also be able to share links of each of the sessions. We just went over that. I'm sorry. We also invite your questions and your comments, which we will attempt to address at the end of each presentation today. We really hope that the presenters can get through their discussions, and then they will allot some time, probably about 10 to 15 minutes if it's possible at the end, and we'll collect the questions and address them. Please look at the chat box located on the bottom of your Zoom screen. If you think of a question for the speakers at any point, just jot it down so that we can collect those. I wanted to just take a minute to express my own appreciation and recognition of the contributions of several folks that have really put this together with everyone's assistance. Angel Buchanan, my very organized and supportive colleague, Ann Clark, Marcia Restivo, Bonnie Patrikis, Wendy Tickler, and Sarah Hanlon, Bridget Farrell, Brian Hesdorfer, Casey Croucher, and Kate Guerin, and many, many others. Thank you all for your guidance and inspiration, your support and ideas for this symposium. Planning committee members are also helping with introductions, as you've seen yesterday, and they're assisting us today with our speakers. We are so very grateful for the NYSARC Trust and the trustees for their ongoing commitment and extraordinary generosity in providing the financial support for this symposium. Last but not least, a very special thank you is extended to all of you who are attending today, and to our very distinguished speakers over the course of several weeks for the time that they put into the pre-planning, their knowledge, their experience, their collaboration, and their expertise on the issues challenging the provision of supports in our services, as well as impacting the lives of individuals with intellectual and developmental disabilities, as well as their families. Now, without further ado, I have the pleasure of introducing another member of the conference planning team, Sarah Hanlon, who is the Assistant Executive Director and COO, Chief Operating Officer from our Otsego County chapter, who will be doing the honors of introducing our next session, and esteemed speakers Sheila Shea and Julie Friedman from MHLS. Thank you.
Good morning and welcome to day 2 of the ARC New York 2022 Guardianship Training Symposium, Autonomy, Decision-Making Supports, and the Changing World of Guardianship. This morning we begin with session 5, the evolving legal landscape in New York State, guardianship and alternatives. Today we will learn from 2 highly experienced attorneys with mental hygiene legal services who will introduce us to the different types of guardianships available in New York and alternatives to guardianship. It is my great pleasure and privilege to introduce our next presenters. Sheila Shea is a graduate of the University of Vermont and the Albany Law School of Union University. She joined the Mental Hygiene Legal Services 3rd Judicial Department in 1987 and in 2007 was appointed as the director. Julie Friedman is a 1993 graduate of Cornell Law School and a 1988 graduate of Cornell University School of Industrial and Labor Relations. Since 1999, Julie has been an attorney with the Albany Regional Office of Mental Hygiene Legal Services and is currently the managing attorney for the Albany Regional and Kingston offices. More information on Sheila and Julie's biographies can be found in the program material. The ARC New York and the ARC New York Guardianship Program have enjoyed a warm and wonderful relationship with Sheila, Julie, and the Mental Hygiene Legal Services in the 3rd Judicial Department, and we are very grateful for their ongoing collaboration. Welcome, Sheila and Julie, and thank you for sharing your expertise with us today.
Hi, good morning. Can everybody hear us? Yes. People
Yes.
Okay, thank you. So let me know when you want me to share.
Okay.
Go ahead and share.
Good morning. We're going to share a PowerPoint presentation with you this morning. So Julie's going to call it up.
Okay. All right. Hopefully everyone can see it. And just so you know, this is really just sort of a guide. We're not necessarily going to follow the slides word by word, but really just to sort of frame some of the discussion and put up some key ideas.
Okay. So I wanted to start by saying that I had the pleasure of participating yesterday and listening to the panel presentations. They were extraordinary. Julie and I titled our program "The Evolving Legal Landscape," and I think you all have a sense from yesterday how dynamic our field is currently, and so I feel as though, you know, a dose of humility here. I mean, Julie and I will go through really more like sometimes in some sense a black letter law presentation with slides, but we really do value and I learned so much yesterday. And Erica, you started this morning by saying you learn something every day, and I really felt yesterday that I came away with some very, very important insights. So and they really guide us, I think, today in this continued discussion. So it's pretty common, I think, when you come to a presentation like this that you identify objectives, but again, I feel as though maybe the objectives have shifted a little bit based upon what we heard yesterday. So Julie and I will walk you through an introduction to our guardianship laws in New York State. For many of you, this will be a review, and you're very well versed in the guardianship world, but we just to lay a foundation, we'll review our guardianship statutes. We will talk about less restrictive alternatives to guardianship. And that last point, legislative initiatives, I had really two things in mind. One was the simplified advance directive, which I want to talk about a little bit later in the program, but then most prominently, supported decision making. And the panel that you had yesterday with Halden, Samantha, Patricia, Michelle, and Devin was so thoughtful. We won't repeat or be able to even match what you heard yesterday in terms of the richness of the discussion, but we'll have a bit of a different perspective, perhaps from MHLS, and we can explain to some degree our participation in the process. Halden spoke yesterday about OPWDD wanting to be very transparent about the supported decision making, and I think they have been. And MHLS was privileged to participate in some of the early drafting, offering comments to OPWDD, and having our concerns brought to them. So we can share a little bit of that as we move on to the program. And the final thing I would say, our program description talked about using some case studies. We do talk about a couple of cases in the materials, and I'll draw to the extent that I can, and Julie will talk about two prominent cases, but the judges that you heard yesterday, Judge Saul in particular from Westchester County, issued a decision recently that I want to talk about. So I'll bring that up later in the program. Okay, thanks. So the next couple slides, I think most of you know us. I don't want to dwell on this too much. Only to say, as you know, that Mental Hygiene Legal Service, we are an agency of the Appellate Divisions of State of New York Supreme Court. So for those of you in the field working in service delivery or guardianship committees or parents, wherever you come from, there will be an MHLS representative in every county in New York State, but there are 4 of us, so we don't have an executive director or a commissioner. Like our structure is different. So Julie and I are in the 3rd department, which is we have the least population, most geography to cover. So we have 28 counties. As far south as Sullivan, and as far north as the Canadian border over west to Elmira. And I'm going to show you a screenshot on the next slide, which Julie said to me yesterday, it was cutting edge in 1990, but it's
Maybe 1980.
maybe 1980.
And there's a live link on the bottom of this slide, so which takes you here. And you can see it takes you to our field offices, the statutes and rules that we're going to talk about, as well as some articles on subjects of guardianships and rights for individuals with disabilities. So if you have a chance, if you have some questions about MHLS, sometimes our ancient website is a good place to start.
Julie, can you go back to the live link? I wanted to just point out something that that link to our website, I just wanted to talk a little bit about the origin of that. The Justice Center for the Protection of People with Special Needs, as you may know, administers the surrogate decision-making program, which is Article 80 of the Mental Hygiene Law. And the Justice Center initially asked us to develop this contact list for scheduling SDM hearings. But it has another valuable function, and particularly during the COVID crisis and in the midst of the pandemic, when there was so much pressure on everyone. Of course, there's still a tremendous amount of pressure on everyone, but there were so many of our clients that we were working with were developing COVID and becoming very ill. Some of whom needed end of life surrogate decision making as a result of their illness. And it was really imperative for us to develop a contact list so that we could have people available during business hours and after hours to assist. So that contact list, I think, is one of the more prominent and important aspects of our website, which is one of the reasons we included it in the program today.
It was accurate probably 4 or 5 months ago. It probably could use some updating, as sometimes we need to rearrange what attorneys cover which county. So if there's ever any doubt, certainly, contact the office in your region if you want an individual contact.
And the agency that Julie and I work for, our origins go back to 1962, and even before that, 1959. And we were a product of a study of the Cornell Law School, where Julie's a graduate of, in the city bar of New York City. And our primary function originally was in psychiatric hospitals. And the only reason I mention this is that most of you are working with clients in the OPWDD system, we have a wide range of functions we perform in the OMH system, and to a more limited extent with OASIS, but we do provide a broad range of protective legal services to people with mental disabilities, not only in psychiatric hospitals, but in other facilities. And next slide, please, Julie. These are, a condensed list of the clients that we serve. On the left of your screen, you'll see that our ability to represent individuals is not limited to people receiving services in facilities. I want to link to that point when we talk a little bit later about the potential that NHLS would be serving as a guardian ad litem in a guardianship proceeding. But also wanted to mention again for this audience in particular, at least the third department, we've been doing quite a bit more work to establish eligibility for services. So these, the OPWDD eligibility process, as you know, can be very complex. And while OPWDD refers to it as the open door process, or they used to, sometimes that door doesn't open easily. And we've been doing considerable amount of advocacy around establishing eligibility for services, and I've been very proud of that work, and I think it's very important. Okay, so I think at this point, we're going to consider more substantively what we're here to talk about today. Why would a petitioner consider guardianship? I remember back probably in 2018, I was with Rosemary Bailey, who many of you know. We were, Rosemary had asked me to work with her on a guardianship project that was being undertaken by the New York State Law Revision Commission. And Rosemary and I were speaking to many different stakeholders around the New York State, and we were in the chambers of a surrogate court judge in Kings County. And the judge said that the primary reason that people come to surrogates court to seek guardianship is for healthcare decision-making. That was her perception. And I don't know if that's your perception as well, Julie, but the judge said clearly almost everyone who came to her court was concerned about healthcare decision-making.
I would say so. I mean, I think it's some of it is age dependent. I think when there are younger individuals where someone is petitioning for guardianship, it's the fear of the transition from someone, you're having your child or family member who's under 18 and now they're over 18, and who's going to protect them, and how can a parent or a family member protect them. But I would say, aside from that, overall, when you're looking at sorry, that's somewhere I will not be right now. Overall, it is probably healthcare decision making, including transfers to nursing homes or other types of facilities within the broad definition of healthcare decision making.
And when we think about healthcare decision making, and we'll talk about this a little bit later, guardianship might be and not necessary in terms of the various surrogate decision-making statutes that are available for healthcare decisions. The other piece, this transition from school to adult services. I was at a conference last week with the New York State Bar Association Elder Law Special Needs section, and we had two panels on guardianship, and we heard from some of the same judges as we heard from yesterday, and Tara Pleat was also very prominent in organizing that conference. And the other thing that typically comes up with 17A guardianships is in particular is seeking guardianship to facilitate this transition from school to the adult service world. And we'll talk about whether guardianship is really necessary for that purpose, but I know from speaking to Tara and from many presentations and interactions with parents, this is a very important concern to parents, enabling that transition to occur, because as I said a moment ago, it can be very difficult to access OPWDD services. The other thing that we see, and I want to put, that's the last bullet point, and I want to shout out, if I may, the ARC, the guardianship, I'm sorry, the trust program that's run by the ARC New York. We have many clients who receive windfalls of property. They may need to place their funds in a supplemental needs trust or a pooled trust. And we certainly value the relationship we have with the NYSARD Pooled Trust Program, Community Trust One in particular. And I know that the trust works closely with the guardianship program, and it's an extremely vital program, and one that we value as attorneys. It's a tremendous resource for us to be able to look to the ARC of New York for trusts and property management. Next slide.
Before we leave this slide, prosecutor or defend litigation, you might not think of that as being something relevant to guardianship, but we have on occasion had clients who were taken advantage of, who've had maybe money stolen from them. And sometimes the best way to bring a litigation to be able to try and recoup those funds is if there's a guardianship in place with a guardian who can then assist in trying to recoup those funds. Also, if one of our, an individual is sued perhaps for something related to an injury or some type of insurance issue, and they don't have the ability themselves to act with a lawyer to defend themselves, they might need a guardian for that purpose. So it doesn't come up too often, thankfully, but it is something that we do see.
Next slide. This slide is entitled Challenging Assumptions, and I had done any number of presentations where we've engaged in some critical thinking about whether or not guardianship is necessary in any particular case. And there are certain assumptions that we want to challenge or to question. And this slide is just designed to kind of think about that. There are less restrictive alternatives. I think you heard yesterday from Judge Saul in Westchester County. He mentioned this video that they use in Richmond County and Staten Island. The Richmond County surrogate does encourage potential guardianship petitioners to tune into this video, and it's well done. It's led. The speaker is a former court attorney who was on the supported decision-making advisory council, and she talks about alternatives to guardianship. Like, if I heard correctly yesterday, Judge Saul said he might want to utilize this video or something similar in Westchester County. The other point here is certainly people can often make their own decisions or with the support of others. And again, you heard some very thoughtful presentations and points on this yesterday. Parents do not have to secure guardianship to obtain access to records. That's a point I wanted to make. In the mental hygiene law, there is a definition of qualified person. A qualified person may obtain access to clinical records. There's a definition of a qualified person at mental hygiene law, section 3316. It does include a legal guardian, but it also includes a parent or other legally authorized surrogate who's on the surrogate list maintained by OPWDD. If that individual is making medical decisions or providing informed consent, that the individual would have access to records. So again, this is a statutory mechanism to afford a qualified person with access to clinical records. And of course, I'm sure many of you are aware that OPWDD regulations recognize actively involved family members as legally authorized surrogates in a variety of contexts, which we'll talk about later. So I'm going to, at this point, Julie was going to take over the next segment of the program, but just to lay the table, obviously we have 2 guardianship statutes in New York. And a person with a developmental disability could be the subject of a guardianship proceeding under Article 81 of the Mental Hygiene Law or the Surrogates Court Procedure Act, Article 17A.
So I'm gonna, I hope no one gets whiplash. I'm sort of gonna move back and forth between the two types of statutes. I think most of these slides were designed not just to give you some background, but really to compare and contrast, because I think it's so confusing for people, and this is for, you know, attorneys and non-attorneys alike, the different types of the guardianships. And I think it's important to point out the differences, because there are real substantive differences that affect individuals with disabilities who are subject to guardianship. And they sort of, these types of guardianships have grown up differently and have different roles. So I think it's important to compare and contrast. So hopefully that won't be too confusing as I switch back and forth. If I had a giant whiteboard, I would put 81 on one side, 17A on the other, and that might be a better way to show the differences. So, but first I'm going to talk about Article 81. Article 81 is the newer statute. It was passed, I believe, or came into effect in 1993, which is as long as I've been a practicing attorney. So right from the very beginning, I remember attending a training that Rosemary Bailey did at Albany Law School the year the statute was passed. So Article 81 replaced the conservatorship, which is what used to be in place for individuals who were thought to be unable to make their own decisions. Article 81 does not depend on a person's diagnosis. It looks at functional limitations, functional impairments, and it could be for any type of disability. So it could be for someone who has an intellectual disability, or for someone who has suffered a catastrophic accident, or perhaps had a stroke. It has to be a rather serious impairment, but it can also be a temporary impairment. Someone who has been in an accident and who may be in a non-responsive state, but who may, you know, get better at some point. And we'll talk about what would happen in such a situation. So it's really any type of disability. It's not diagnosis driven. It's driven by functional limitations. It's brought in either Supreme Court or county court, so not surrogate court. It's a different type of court. And although there are some exceptions where surrogates court can have jurisdiction over these cases, sometimes there's an estate proceeding and then there's this type of guardianship that's brought. But usually they take place in the Supreme and county court, which really has different types of procedures than surrogates court. So instead of talking about who might be, I mentioned a little bit who might be subject or what we call an alleged incapacitated person under Article 81, but this is who might be able to serve as guardian. So anyone who's over the age of 18, it could be a corporation, like if it's in a charter for a nonprofit like NYSARC, a public agency, including the local Department of Social Services, who we sometimes think of the guardian of last resort if there's no available family member or friend and someone is in need of a guardian. They're appointed by the court under the terms that the court sets. And the person who acts on their behalf, they might be making only personal decisions for the individual, which would include medical decisions or where they live, for example, and or property management. Property management obviously includes benefits, the sale of homes, the managing of bank accounts, benefits, or income. Now, in contrast, 17A is a statute that only applies to people with developmental disabilities, and the statute has changed some of the terms over the years. They have phased out using the term mentally retarded and have replaced it with developmental disabilities. It's more globally inclusive. It also includes individuals with traumatic brain injury. That was a group that was folded in fairly recently, I think within the last 20 years, into 17A. The proceeding is commenced in surrogates court, and the petitioners rely on forms that have been created by the Office of Court Administration. And because these forms exist, this is an easier process for individuals to do without an attorney. Under Article 81, by contrast, you would bring what's called an order to show cause, and there would be a petition, and maybe there would be affidavits. But these are forms that attorneys might use in a variety of cases, not just guardianships, and it really has to be tailored to the facts of the particular case. Although there are sample forms you can find online, I think in the Broome County website court system, you can find some examples, but it's not a sort of fill in the blank, which the Office of Court Administration has designed for surrogates court. And part of that is because surrogates court, which is primarily known for handling estates, has always been a very form-driven type of court. They have forms for everything, forms for opening security boxes for people who have passed away, forms for paying for a funeral for someone who's deceased, forms for if there's no will, if there is a will. So it's a very form-driven type of court. So they have forms for guardianship and for different types of steps along the way in the process. And there's a link there to the forms. So there's a couple of different, I already talked a little bit about filing a petition, but these are a couple of different areas where the two guardianships have some contrasts that people should just sort of be aware of. So this is a little out of order. This probably should have been the first slide in the section, but we talked a little bit about filing the petition. One petition gets filed in surrogates court. One petition gets filed in Supreme or County court. And I'll say usually the Article 81 type of guardianship is being filed when something has happened. There's been an illness, there's been a catastrophe, there's been a sudden or maybe not so sudden realization that someone may not be able to, can no longer care for themselves. It could be something that is triggered upon someone reaching the age of majority, but more often than not, something has happened. Who can file? I'm going to get to a slide, talk about that in a little bit. The role of MHLS is different in each type of guardianship. There's something called a court evaluator in Article 81, which I'll talk about. I probably should have a box that says guardian ad litem. There's something called a guardian ad litem that might come up in a 17A, and I'll get to that in a minute or two. But it's also important to know that the hearing and legal standard are different for both types of cases. So Article 81, there's a whole list of people who can petition, and this comes right from the statute. So person who's alleged to be incapacitated can do what we call a self-petition. And we have, on rare occasions, represented people who say, I need a guardian. Someone is taking my money, I need a guardian to protect myself, and so somebody can help me go after them. Or I've developed someone who might have developed a medical condition where they need some assistance and they don't think something like a power of attorney or a health care proxy would be sufficient. So they might feel that they need a guardianship for various reasons to render them some assistance, but they recognize that need. So they might be willing to consent to a guardianship, and that would be what we call a self-petition. So there's a whole list of other people, family members, in agencies such as Department of Social Services, someone involved with a trust, someone involved with an estate, the chief executive officer, this is number 7, or the designee of a facility where the person is a patient or is residing. We see this a lot with hospitals, nursing homes, and other types of those types of institutions or facilities. Number 6 says a person otherwise concerned with the welfare of the individual. And this is sort of a catch-all. And I've only seen 1 or 2 cases where the petitioner was really questioned as to whether or not they met number 6. And in that case, it was a landlord. A landlord filed a petition and they said, well, I'm very concerned about my tenant. We're good friends. But a quick fact investigation turned out what they were concerned about was being paid their rent. They weren't really concerned about the individual. They wanted a person appointed guardian so that the rent would be paid. We were able to resolve that issue without a guardian being appointed. And one of the problems with the case is the judge felt that individual really didn't meet the criteria to even be a petitioner because they weren't really concerned with their welfare. It was really a fight. It was trying to use Article 81 as a financial mechanism to be paid under a landlord-tenant agreement. Most of the time, petitioners are family. We see a lot of cases where the petitioner is the Department of Social Services as well. Article 17A also indicates who can petition. It's usually a family member. It's usually a close family member, but it also can be someone who's interested in their welfare. But in most cases, it's a parent, it's a sibling, it's a cousin, it's an aunt, it's an uncle. But we have had cases where there are maybe former service providers or a close family friend after family members have passed away, who can petition for guardianship. There are some exclusions that also would affect any type of guardian or fiduciary, and that can include people who have certain types of criminal records, and also people who may be excluded because they have had charges against them relating to being a fiduciary, such as, let's say they were managing someone's money and they were convicted of fraud or had to pay some civil penalties for mismanagement of funds. There's also a question on the 17A forms about whether or not someone is a potential guardian is addicted to drugs or alcohol. So talk about the role of MHLS. In an Article 81, our agency can be appointed as counsel for the individual who may need a guardian. Not as counsel for the petitioner unless the petitioner is someone we've identified as a client. And I want to be clear, because this comes up a bit, that we would only represent a petitioner in very limited circumstances, because our role is representing individuals with disabilities. And we would only bring a guardianship on behalf of one of our clients, really in one of two cases. The first situation I already mentioned, where an individual sort of is self-petitioning. They want to petition, usually it's because they're being exploited in some way, and they feel that they need the protection or assistance of a guardianship. They're recognizing that they need assistance. They may not have someone they can appoint under a power of attorney or a healthcare proxy. And so they may need, for example, the Department of Social Services, or maybe an attorney they don't know, but who would be appointed by the court to serve as a guardian. The only other time is if we have a client who we feel needs protection, who is intellectually disabled or developmentally disabled, but is so impaired that they're unable to tell us whether they would want us to take this step. So they're not objecting to it. They're also not consenting, but they're unable to guide us as their counsel. But for one reason or another, we've determined that they need the protection of the guardianship. An example that we've had within the last year or so was someone who a family member wanted to remove them from a residence. We had sufficient reason to believe that that would not be in the person's interest and could in fact be dangerous for them. And so we brought a guardianship in order to protect that individual. And this was, of course, after significant fact finding. We would never do that lightly. Our client was too impaired to have a discussion with us about whether or not they wanted us to do that. But because there was ample evidence that it was in their best interest, we brought a proceeding to have a guardian appointed for them.
Really, can I comment on this? Sure. I wanted to just build on what Julie just said, that there are instances where we have clients, I feel, who have been in extreme jeopardy, and we have utilized Article 81 to protect them. And I also feel that that's consistent with our ethical duty as attorneys. But there's another instance I wanted to mention that was more of a case that it was a property case that just arose within the last month in St. Lawrence County, just to give you another example of how the guardianship statute can be used to assist someone. So our office in St. Lawrence County was contacted by a provider of service, an OPWDD voluntary agency, and a family member, because our client, who was unable to express his wishes and has a profound intellectual disability, was a beneficiary of an estate in Wisconsin. And he was unable to participate in the Wisconsin probate proceedings. The attorney trying to represent the estate in Wisconsin had no ability or no resources to have a guardian ad litem appointed in Wisconsin for this individual in New York. And our office decided that we would commence the proceeding to have a special guardian appointed for the limited purpose of appearing in the Wisconsin probate proceeding, to enable this individual, our client, to participate in the probate proceeding and also eventually to receive an inheritance. The other interesting aspect of this case, which I had never heard before, but the client was the oldest sibling, and his father was a veteran of the Korean War. And upon his father's death, the father wanted his remains to be at the Arlington National Cemetery in Washington, D.C. And what we learned in the investigation is that Arlington would not permit the remains of this veteran to be disposed unless the oldest child consented and made the arrangements. And the oldest child was our client, who was in the facility in St. Lawrence County. So that was the other reason to participate and commence that guardianship proceeding. We just made a judgment as an agency that would be a proper utilization of our resources to assist this individual. And so some of these unique fact patterns arise that we can't predict, but I have felt over time that the Article 81 guardianship statute gives us a little more flexibility from the 17A statute. We can talk about that later, but Article 81, the way it's drafted, has more remedies, and they can be time limited and they can be tailored, and sometimes they're just what's needed to handle a situation that's unusual. So these examples that Julie and I have talked about, I think, lend themselves well to Article 81. The only other thing I wanted to say on this slide is the point regarding guardian ad litem and MHLS appointments. And this came up yesterday during the judges panel, and I just wanted to briefly comment about it. So there really isn't good data on the number of 81 proceedings that are filed, or I'm sorry, 17A proceedings that are filed every year, but with the Office of Court Administration, we've been able to extrapolate data. So I had a window of data from 2016 to 2019 that I was looking at the other day. The data revealed over the course of those 3 years that there are approximately 1,800 17A proceedings filed every year. And Judge Saul alluded to this yesterday, that I think he said in Westchester County, he might see 8 to 10 applications every other week. In contrast with Judge Guy in Broome County said he might see 1 or 2 a month. Julie Friedman here at Albany is with a high volume court and Albany Surrogates Court. And I don't know the actual numbers, Julie may have the data, but we see that's a very intense court in terms of the volume of cases. But overall, roughly 1,800 cases over this 3-year window. Now,
That seems low to me.
it might be low, but I don't think we have really firm data. But I only mention it because the Article 17A statute does provide that MHLS, we'll talk about this in a minute, but MHLS will receive notice of a guardianship proceeding if the person resides in a facility. And the data was reflecting about 1/3 of the cases that we see, roughly 600 a year, would be where MHLS is getting notice because it's a person who resides in a facility. So the other cases are probably people who live at home, people who are in non-certified settings. And the question becomes, do those individuals require guardian ad litem? And the courts, and I think you got the impression and the feeling from the judges panel, the courts handle these in different ways, and it's true. The statute does not guarantee the right to counsel, but some courts will appoint guardian ad litems. the third department, MHLS, will accept guardian ad litem appointments. I don't know, so the other departments are doing that. And I think that there's a desire to do this work, but if we're unable to do it, it's because of resources. I mean, it's just, to me, this is a resource-driven question, and we have tried our best to find the resources to do these cases in the third department, but I know Julie can speak to this. It's a burden on the staff.
Well, and part of it is because that we take so seriously, the work that we do, that, and let me just talk about what a guardian ad litem is. A guardian ad litem is, it's concerned some parents when we've contacted them and said, oh, I've been appointed guardian ad litem. It's not a guardian in terms of decision making. A guardian ad litem is usually an attorney that is appointed to represent a party with regard to a specific legal proceeding. So in our sense, you know, as a guardian ad litem, we would look into whether a 17A was appropriate. We report our findings to the court. If we oppose, if we think it's inappropriate, or if the individual who would be subject to the guardianship is inappropriate, is opposing, we may switch to more of a role of as counsel. But what we do as guardian ad litem, so let's say, for example, a family member files a guardianship petition for their, let's say, their adult son who lives at home with them. In Albany County, Judge Pettit wants to make sure that she doesn't appoint a guardian for someone unless it's appropriate to do so. And she doesn't necessarily feel that her having a hearing in court is the only way to find out that information. She wants us to investigate. She appoints mental hygiene legal service to investigate. We meet with the individual, sometimes more than once, depending on how easy or difficult it is to communicate with them. If they're living at home, we'd like to see where they live, but we might also want to meet with them in a place that might seem more neutral, such as a day program or a school. Very hard to do during the pandemic. We also want to talk to the petitioners, and many of these cases are pro se, so parents or family members filed them without an attorney. But even when there are attorneys are always usually encourage us to talk to the petitioners. We might talk to a service provider just to get an opinion on the individual's functioning, but also are the advocates, are they good advocates? Are there any red flags? Are there any concerns that they may have? Concerns such as maybe the purpose of the guardianship is not so much to support someone, but maybe to interfere with independent decision making, or maybe there are questions of abuse or financial exploitation or something of that nature. So we don't just review the petition and say, oh, it looks like all these boxes are checked off. There are certifications as required by two physicians or a physician and a psychologist. That's not how we operate. We take these cases very seriously. You're dealing with a person's autonomy and functioning. So we have a number of steps that we have to go through, and then we have to do a report. And so it takes some time. So we take on these cases because we think it's important, but by taking them on, we're also acknowledging that there's a process that we need to go through. So sometimes people get frustrated that it takes us a long time. Albany probably has the highest volume for the counties that we cover here at the Albany Regional Office. I would say on average, we receive one a week. I think we get about 50 a year. And there are many counties where the judges do not appoint a guardian ad litem. And instead they call the parties in so that they can maybe judge for themselves whether the person might need a guardian based on their interaction with the court. Some courts appoint other attorneys, private counsel as guardian ad litems, or they might not appoint anybody. I mean, like we pointed out, one of the major differences as an advocate, as an attorney, is that there is no right to counsel under 17A for someone who might be subject to a guardianship. And I mean, there's a number of reasons behind that. I think the main reason is the statute was created with the assumption that the disability and the impairment and the need for a guardian would be obvious. That these are for individuals who will never be able to make their decisions. The awful stereotype is that of the sort of perpetual child. And so there wouldn't really be any question, and these are family members, so why would they need counsel? Everyone is well-meaning and honest, and so, and it's not that those things aren't true, most petitioners are certainly well-meaning. But it doesn't really recognize the differences in the types of disabilities or the broad range of functioning that someone with a diagnosis of a disability may have. And it doesn't really recognize that that individual may have agency, may have autonomy. Most of judges are happy to have MHLS involved because we can bring to their attention any issues that there might be. And in some cases where guardianship is not appropriate, help to fashion a resolution. And I think you heard a lot about that yesterday during the judge panel. So just to quickly sort of sum up our role in a Article 81 guardianship, we may be appointed counsel for the person who is alleged to be in need of a guardian. We may be appointed court evaluator, which has a very similar role to a guardian ad litem. Court evaluator is takes an impartial look at the petition and the person who will be subject to the petition, looks at the circumstances from a financial perspective, what are their property issues, from a decision-making perspective, what decisions can they make, what's going on medically, and reports that in a report to the court, answers a number of questions about the situation, including opining on the ultimate question about whether or not the person needs a guardian, who the guardian should be, and what powers the guardian should have. So that's what a court evaluator does in an Article 81 case. We do a lot of that work. And then finally, in some rare situations, we represent a petitioner, which is usually the individual with a disability themselves, self-petition. In 17A, we are guardian ad litem. In many cases, if they reside in a facility, such as a community residence or developmental center, we would take on the role as counsel. So those are just different types of involvement that we have. So the standard, again, we've sort of talked about this a little bit, but under an Article 81, it's a functional standard. And the statute says the appointment must be necessary in order to provide personal needs and to manage property or financial affairs of the person. And either the person agrees to the appointment, and this is under Article 81. Technically, 17A doesn't really provide for consent because it's assuming a certain level of disability. But under 81, someone could say, you know what, I acknowledge I need help, I need a guardian. Or the person has to be found to lack capacity. And only in those two circumstances can the court appoint a guardian. So this is the definition that's in the Article 81 statute. If the person lacks capacity when he or she is likely to suffer harm because they are unable to provide for personal needs and property management, it really should be or, because you can have a guardianship just in one of those areas. And that they can't adequately understand and appreciate the nature and consequence of such an ability. So let me give you an example. There could be an individual which, let's say, due to advancing dementia or some other cognitive impairment that has had that they were not born with, or that perhaps has worsened over time, they have stopped being able to make their doctor's appointments and filling their prescriptions, and they have medication they need to take, and they're not taking their medication because they forget. Maybe they're having mobility issues, so they've stopped taking out the garbage or being able to shop at the grocery store. Somebody becomes concerned, they're likely to suffer harm because they're not attending to their medical needs. And maybe the safety of their home is compromised because they haven't been taking out the garbage, and their nutrition is suffering because they've stopped going to the grocery store and are having difficulty preparing meals. Now, in one situation, the person might recognize it and say, you know, I just need help and I didn't know how to get it, but I have resources or I have Medicaid, so I can arrange for, I'm agreeable to having a visiting nurse come and see me and help set up my meds and take my blood pressure twice a week. Senior services of the county I live in, they offer some services of helping to get to appointments. teaching me how to call for a Medicaid tab, for a doctor's appointment, and I'm willing to accept that help. I have a neighbor who says that they will help me go to the grocery store. I'm going to use one of the, shop at home services, Hannaford. I'm going to call them up, tell them what I need. Someone's going to deliver my groceries. I'll sign up for Meals on Wheels, and I have someone who can take my garbage out for me. And I have a nephew who I'm going to ask him to help me with my banking. So that person has been able to now recognize that they have some limitations and they're willing to accept some help. So that person probably doesn't need a guardian. By contrast, you could have someone who has all of those things going on, but either is unable because of impairment or unwilling to accept assistance. They won't have an aide in the home. They think they can do everything on their own, or they're really not able to realize that their home situation has become untenable. And in that situation, they may need a guardian to put in place staff to help the individual, to arrange for Meals on Wheels, perhaps to arrange for an aide, or maybe even to change the person's housing situation so that they're somewhere where they're safe. So those are sort of the two situations that you can think of. So when determining incapacity under Article 81, again, it's functional level and the personal limitations of a person, and not a diagnosis. So saying someone has dementia or saying that someone has a traumatic brain injury is really not the end of the question. It's only really the beginning of the inquiry. Contrast that with Article 17, where this is from the statute, where it appears to the satisfaction of the court the person has an intellectual or developmental disability. The circuit court can appoint a guardian if it's in the person's best interest, and the person or the property or both when it's in the person's best interest. So you can see it's really diagnosis driven.
Can I interject Julie on this side? So I wanted to point out there was an interesting case in the appellate division, second department, that's was decided originally out of Dutchess County, and it's reported as matter of Robert C.B. We have a slide on Robert C.B. a bit later. But what I found so interesting about this case, Julie, is the appellate division, second department, looking at the best interest standard, because this was an appeal from a 17A decree. The appellate division panel, when you get to the appellate division, you typically have 5 judges on a panel, and the judges in this panel said that the term best interest as it appears in 17A has been aptly described as amorphous and, quote, understanding the functional capacity of an individual with disability, what an individual can or cannot do is a necessary inquiry in determining best interest and the necessity of a guardianship. So to me, I was reading CB and thinking that the appellate division, second department, in construing best interest is drawing on that functional capacity test that you talked about in slide 19 and almost merging. I mean, to me, it seemed like a merger of 81 and 17A standards. But so, I mean, that's when we talk about the evolving legal landscape, going back to the title of our program, I feel over time that the appellate courts in particular in construing 17A often read it in a way that might actually conform with 81. So it's interesting.
And I think, personally, I think some of that has to do with the evolving way that people see individuals with disability and limitations. Since the Americans with Disabilities Act, the general public, which of course includes courts, are more likely to see that autonomy itself could be in someone's interest. The ability to make decisions for themselves, good decisions or bad decisions, is in itself a best interest. And we've had that come up in 17A cases where part of the discussion with the court has been that an individual, especially sometimes a young adult, the impact it would have on them if they feel that more than a safety net, but that the parents would actually going forward be continuing to make decisions for them as opposed to maybe with them or in support of them. And that itself, you know, is something that can be considered. So I know we're gonna do questions at the end, but I just saw something in the chat. Catherine Conroy says, how often does someone who's in the situation that I described willingly accept help? It happens sometimes. I mean, and sometimes that's the role of counsel or court evaluator in a guardianship case where we might say to someone, these are the problems that we see, and let's figure out a plan. Because if you can't figure out the plan, if you're unwilling or unable to accept some assistance, then the alternative might be something that you really don't want, like leaving your home or having someone appointed to make decisions for you. I've been involved with cases where people have said that they would accept certain services and then for some reason don't, or it falls apart, and then the guardian, we may have to go back into court. Or where the person, you know, from the beginning is not willing to accept any services at all. But I've had many cases where the Article 81 was really just the starting point of a discussion of what kind of help somebody needed, and maybe trying to identify an individual who could help them so that they could get the assistance they needed so that they wouldn't be in any kind of peril, but that a guardian wouldn't be appointed. And there is a case, and I can't remember where it's out of, where a woman refused to, I think, meet with the court evaluator, showed up in court, although I think on the wrong day, because there had been some confusion about the date. It was a woman in her 90s who took, like, you know, the 2 buses or the subway, I believe it was down in one of the 5 boroughs in the city, came to court, was able to articulate, you know, she makes her own decisions, she wants no part of this guardianship. That in the end, the guardianship was dismissed. You know, someone had sort of, you know, people can jump the gun on bringing a guardianship case. But part of that case, and I don't remember all the facts, was that this woman was someone who sort of had the ability to express herself, had the ability to get herself to the courthouse, present herself in an appropriate way, articulate how she takes care of herself. And so there was no need in that case for a guardianship. So this talks about sort of the form of the judgment or decree. And, you know, as an attorney, we like things to be thorough, and we also, as an advocate, I want things to be specific in terms of what clearly showing what decisions, what powers a guardian would have over someone whom a guardian is appointed for. Under Article 81, there's an order, a judgment, or an order or a judgment, and it's usually quite long because it lays out a lot of the requirements under the statute. Who is the guardian? What type of decisions are they able to make? What type of decisions they're not able to make? And there's a fair bit of boilerplate that we include about how they have to recognize the individual's autonomy. They have to visit them a certain number of times a year. They have to take a training, whether or not there's a bond, and that's going to depend on the financial circumstances. Who will receive the required yearly reports? The statute indicates individuals who must receive reports, but sometimes there are other individuals who are added. Who should get notice of future proceedings? Whether there's any restrictions on changing somebody's residence. So it's quite detailed, and the commission is sort of a 2-page thing that you can easily present to a physician or a bank that says, hey, I'm the guardian and I'm able to make decisions. But the order itself is usually quite lengthy and quite detailed. By contrast, the 17A guardianship, there's letters, usually letters and a decree. The decree says the court has made this decision that this person is a guardian, and the letters say, hey, I am the guardian of this person, show the letters to the bank, to a doctor, to a provider. And it doesn't list any kind of powers other than to say whether it's person, property, or both. But there's usually no delineation of powers. It may indicate something about medical decisions. Medical decisions have to be made in accordance with existing statutes. And in some cases, some judges will allow for some tailoring of the guardianship, of the 17A guardianship. And I think we heard about that yesterday from the judges.
Just if I can interject, I thought that was a very interesting discussion yesterday, and I imagine people in the audience found it fascinating too. in particular, Julie, the potential that a 17A decree might have a limited duration, particularly for an Article 17A respondent who's young, perhaps in the age 18 to 21 range. And in our practice in the third department, I've seen, particularly along the Canadian border, Franklin, St. Lawrence, and Clinton County surrogates in the past have tailored decrees, made them of limited duration. I haven't seen that as much in Albany County or even in Binghamton, but Judge Guy said yesterday that he might consider that. So it's interesting. Again, when we talk about the evolving legal landscape, and it came up last week at the Elder Law and Special Needs Program as well, just an enhanced recognition of the various capabilities of people with developmental disabilities and kind of this general knowledge about development, and just bearing in mind that people can acquire or gain ability skills as they age. And it's this idea of a limited duration guardianship, I thought was something that was interesting and emerged yesterday.
Well, there's a couple of slides coming up about termination and modification of the guardianships, but I just want to pick up on where Sheila left off. But first, let me say, we've talked about how the powers of Article 81, powers authorized by court must be very specific. 17A usually is plenary, which means kind of an all or nothing, but sometimes some courts will tailor them. But in terms of timeframes, I have had guardianships both in 81 and both in 17 that have some type of time component. So for example, in an 81, I've had a client a couple of years ago where they were having some medical issues. They consented to the guardianship, and it wasn't really clear that they would need a guardian forever. And so what we've done in that situation is said, we're going to set a conference down for a year or two forward, and that we would then sort of reconvene to see whether the guardianship was still necessary. Different judges have handled it different ways. Some judges say, let's set it down for a conference. Some judges say that this guardian will expire on this date unless there is an application by one of the parties to continue the guardianship. So there are different ways to deal with it. In the 17A context, and this mainly has come up, as Sheila mentioned, with sort of younger individuals. Sometimes there's someone who's a young adult and maybe they're pretty high functioning in terms of they can do a lot of things on their own. And it's really hard to know what kind of decisions they're going to be able to make for themselves as they age. Because sometimes by youth or inexperience, someone is unable to do things. Or maybe it having to do with the environment where they were, if they were residing in a home where maybe there wasn't a lot of care. And I've had this case, they're residing where there wasn't a lot of care and they weren't attending school and they weren't attending a day program, but now maybe they're in a different living situation, attending a day program, and they may acquire abilities to make decisions for themselves. So when we've seen cases that we think maybe look like that, some judges in surrogates court proceedings are open to saying, this guardianship is going to be limited for a year or 2 or 3 years, and then we're going to come back and see whether it should continue. And we've had some cases where the guardianships didn't need to continue because the person, or maybe they needed to be narrowed a little bit because the person was able to gain some skills, and so they didn't need a guardianship anymore. So I'm going to talk, and I'm going to probably go a little quick because we don't want to run out of time, but let's talk about modifications. So in an Article 81, we've talked a little bit about someone's circumstances can change. I had a client who had a stroke, and they got better, and they were able to make decisions for themselves. Under Article 81, the guardian, when they do their annual report, they have to indicate whether or not there should be any changes to the powers. And so they have a responsibility under the statute to notify the court if they think they need to expand powers or to eliminate powers. I had a client years ago who really only needed a guardian of her person initially to help her with medical decisions. She became unable to make her own medical decisions. But she seemed to be able to handle other things okay. But then she wasn't. Then she needed more assistance in finding a residence and convincing her to leave her home, and dealing with some other circumstances that arose. And so they needed to expand the powers. Sometimes it's the reverse. They're okay with their personal decisions, but they can't manage their finances, and then maybe they can't manage anything as an illness progresses. Under 17A, modification is permitted, but there's no obligation on the guardian to go back to court. There's no legal obligation if they recognize things have changed. You might say there's a moral or an ethical obligation, but there's no legal obligation to do so. But the court does retain jurisdiction, and they can go in and modify to either enlarge powers or to contract powers. We see this most frequently where there was no property to manage, so they didn't need to be guardian of the property, and now the individual they're guardian for may inherit some money. There may be a need for financial planning, and so now they might want to add a guardianship of the property. So termination, the court appointing the guardian, they can discharge or modify the powers of the guardian where appropriate. A guardian can be discharged if they're not doing a good job, or if they're no longer interested in being guardian, or if they themselves become incapacitated, and this would be for either statute. Or the guardianship itself can be discharged when the person no longer needs a guardian. Under 17A, there's always the ability to go back to court to petition to have the guardianship discharged or to have a successor appointed. Article 81 specifically spells out how you do it. Article 17A doesn't really, but you can always go back and petition the court. So this is the Robert C.B. case, which I think Sheila talked about.
Yes, and I just, for purposes of the slide, there's a note, the court, the Dutchess County Surrogates Court removed the guardian of the person, but maintained the guardianship of the property. The case went up on appeal. Now, the appeal was decided, and on appeal, the appellate division also terminated the guardianship of the property. And the case is a good example of changes in circumstance. So as the slide reflects, Robert was a 17A respondent, but he had two food industry jobs. He performed well without accommodations. He was able to get himself to work, to his doctor's appointments, and he had a high school diploma. And the property guardianship, which was ultimately reversed on appeal, in the court, the surrogate was concerned that Robert had been exploited in certain transactions by predatory salesmen when he purchased an automobile. And the court was concerned that he really wasn't able to manage his finances. He also has a supplemental needs trust. So that really was outside of the guardianship. But on appeal, the appellate division saw the record a little bit differently and felt that Robert showed through his testimony and his actions that he understood the consequences of his decisions relative to managing his finances, and that he really was able to exercise his own decision-making. And but so the appellate division did reverse on appeal. But again, it demonstrates the point that Julie's making about 17A, which is the surrogate court does retain jurisdiction, and there can be petitions to terminate or modify the guardianship. And Judge Saul yesterday spoke about a case that he had, was very interesting, and it's just been reported. But in that particular case, I won't spend too much time on it. The 17A was awarded, or the decree was issued when the respondent was 18. But by the time the respondent was 24, he had graduated from high school. He had actually obtained a college degree and was in a master's a social work program. And he had an aspiration, a goal to be a social worker and wanted to work with children with autism. And his parents, who were his 17A guardians, went back to surrogate's court to petition to terminate the guardianship proceeding. And then that Judge Saul, in a thoughtful decision, did grant that relief.
You know, we've had a number of cases where guardianships under 17A were appointed maybe many years ago when an individual who's maybe now in their 40s or 50s was 18 or 19. And it was in a county where counsel wasn't, or guardian ad litem was not appointed for them. In some cases, they didn't even know that a guardian, if the court didn't hold a hearing, because the court has some discretion to dispense with the hearing. Some cases, they didn't even know that they had a guardian, that the guardian was appointed for them. And maybe at some point, they discovered it. And they could be someone, we have an individual, and there's lots of cases like this, who get some assistance from an agency, from a voluntary agency, but basically lives alone and works full time and this one has a license to operate heavy machinery and has a motorcycle and really didn't need a guardian. The issue came, he didn't want to offend a family member who was his guardian. And so it involved a lot of, diplomacy. He didn't want to have a guardianship anymore, but also didn't want to be involved in a contested proceeding with a family member who thought they were doing their job at protecting the individual. It's also come up individuals who want to engage in sexual activity, who want to get married, and a guardian who maybe really hasn't been exercising a lot of decision-making that was obvious to the individual says you can't get married or you can't move in with this person or you can't engage in sexual activity. So those are some of the fact patterns that we see. I think there's a much more of a recognition in surrogate court now of the abilities that individuals have with disabilities to direct their own life, whether all of their decision making or some of their decision making. And so I don't think we see as many of those cases as we used to. I don't think you'd see a case like that today where someone, I hope it would, where someone didn't know that a guardian was appointed for them and they had the ability to know and participate, but were not given appropriate notice. So Erica asked, why do some surrogate judges feel Article 17A does not allow for tailoring and some feel that they can tailor it? It's really more of a judicial philosophy. Some courts feel that they're bound by what the statute says. The statute doesn't include provisions for tailoring. The statute says best interest, personal needs, property needs, and doesn't really include what Article 81 says. Some judges have said in decisions that they think that the protections of Article 81 should be read into 17A, that without that 17A doesn't make sense. They feel they have that discretion, and so they're willing to tailor it. Until the Court of Appeals really comes down one way or another, we will continue to see that, or to statutes revised, we will continue to see that discrepancy in the state.
Julie, I would say to Erica's question too, there, just as another example, we've had several cases where there might be a 17A respondent with two devoted parents, but the parents are separated, estranged, divorced. And the issue might be visitation. And if you read Article 17A, the text doesn't speak to visitation by a non-custodial parent for an adult with disability. And so we've had, to your point, Erica, we've had counsel argue that a judge can't order visitation. It's not within the four corners of the statute. But we had a case like this go into the Appellate Division 3rd Department where a panel of a unanimous decision, the Appellate Division said yes. 17A can provide for visitation. A surrogate court can craft a visitation order. So again, I think it comes to Julie's point about judicial philosophy. And again, this evolving legal landscape where a particular set of facts might lead us to a legal ruling that reads certain protections or certain rights into a statute that aren't facially provided.
And unfortunately, law doesn't always provide a clear answer. Hopefully you can still hear us. One of the disadvantages of doing this remotely is, we don't know when they're doing the yard work outside our window, but it sounds like they're using a lawnmower or a leaf blower. I hope people can still hear us. Really. I don't.
We
But
can,
tell
we
someone
can.
Not making noise. If it's possible. Anyway, so limitations of guardian's authority, okay, great, thank you. Okay, so they say that they can hear us fine, so, but in any event, I'm talking louder. So, they talk about, there's actually, we could spend a whole session just talking about the limitations of guardian's authority. There's actually a lots of different types of limitations, but in this example, and I think that any attorney who's been in this field long enough has a case like this. The case I had to do with whether or not the guardian could decide how someone should dress and how their hair should be styled, not by the guardian, but by the people in the community residence where the individual resided. So in Leo R, the 17A guardian had a lot of requests. That person was in the Broome Developmental Center, and that's where they were receiving services. And they wanted to use the guardianship sort of as a sword to compel the developmental center to do certain things that had to do with access anywhere, anytime, and also the specifics of how he would be monitored. That's not really a proper subject of a guardianship, that kind of micromanaging kind of thing. And this is a case that was litigated, and the court determined that, yes, those were not things that were proper role for a guardian. Because there's a difference between saying, I want the individual to have this surgery or not have this surgery, as opposed to saying, don't wake him up and force him to get out of bed until he was ready. Sort of very odd facts. Courts don't have the authority to interfere with the discretionary acts of the administrative agency. Is really what Leo R was talking about, which can include treatment plans as developed by the agency. But it's very, very fact specific where that line is. And as practitioners in the field know, 14 NYCRR 63312 is really the vehicle for making objections to treatment. So objections to how medication is administered in the facility, objections to day programs, let's say, the level of supervision the individual has. That's really the proper forum, because people who provide services to our clients, they're not babysitters, they're service providers, and services often have to be provided in a certain way, and a guardian is not able, just because they're guardian, to say, I'm going to dictate exactly to the minute how care is provided. This is sort of, we've talked about the differences between the statutes, and Sheila, do you want to sort of talk about sort of where things are currently with 17A?
No, Julie, thank you. So I certainly think that this language from the practice commentaries, Margaret Toronto's commentaries, captures it well. I think the 17A is viewed as simpler, more straightforward. Many 17A petitioners are able to proceed without the assistance of an attorney. It results in significant cost savings. So 17A has endured and enjoys significant support, and we understand and respect that. There is, if you go to the next slide, Julie, the problem is that, as we talked about, and the disparities between the Article 17A statute and the Article 81 statute have given rise to litigation. I think many of you are aware there was a federal lawsuit that had commenced by Disability Rights New York to challenge the statute. It was dismissed in the federal courts on abstention grounds, not on the merits, but on abstention, with the federal court saying this is really a state law question. Most of the 17A proceedings are not contested, but in those that are, the disparities between the due process protections, for example, the right to counsel, the burden and standard of proof, those disparities do give rise to constitutional concerns. And so there have been, as I mentioned earlier in the program, the Law Revision Commission has been looking at potential modifications to Article 17A. The Office of Court Administration has also drafted a bill. It was not introduced last year, but there is a program bill that's circulating at the Office of Court Administration, which essentially would permit our dual structure to continue in New York and permit the dual two guardianship statutes, but enhancing the due process protections that are embedded within the 17A statute to address the constitutional concerns. That's where I see it moving, Julie. I do see continued study and stakeholders arguing for reform of 17A. Litigation may arise in particular situations, that's unpredictable. But I do think that we will see some changes to 17A, although I think 17A and 81 will probably survive as discrete statutes.
And there's an article in the materials about civil rights perspective that talks about this, and that's available also on our website. So we don't have a lot of time left, so I think we're just going to power through a couple of things so we have enough time for questions. So there are a number of alternatives to guardianship, and I know I saw quickly there were some things in the chat. Healthcare proxy, which I'm going to talk about for a minute or two. Simplified advanced directives, which Sheila is going to talk about. Supported decision making, which has been alluded to, but if time permitting, we'll go over that as well. Also, OPWD, legally authorized surrogates, powers of attorney, representative payments, such as a representative payee for receiving the Social Security benefits, special needs trusts, ABLE accounts, which also deal with another way to have money in an account without interfering with Medicaid. These are all things that can be done maybe to address specific needs short of a guardianship. And of course, the surrogate decision-making process, Article 80 of the Mental Hygiene Law, which is medical decision-making for individuals who do not have a guardian or a family member to make a medical decision, and they either reside in a facility licensed by OPWD or they used to, and now let's say they're in a skilled care facility. So those are just some of the other vehicles. I'm not going to spend a lot of time talking on public health law. There's a number of slides on it. But just really to sort of summarize, this is under the public health law, and a healthcare proxy is a document that an individual signs to give the authority to someone else to make healthcare decisions for them when they become disabled. So for example, I have a healthcare proxy. Every adult should have a healthcare proxy. So if something should happen to me and I am either permanently or temporarily unable to make my own medical decisions, so I am now incapacitated, I lack capacity either temporarily or permanently, my husband can make medical decisions for me. You cannot sign a healthcare proxy for somebody else. So I can't, if I was guardian for someone, I can't sign a healthcare proxy for that individual, because signing a healthcare proxy is I am delegating my decision-making authority to somebody else. I have to have the capacity to be able to do that. The agent is the person who makes the decision. The principal is the person who is delegating the authority. There's some explanations about what a healthcare decision is. every adult is presumed competent to appoint a healthcare proxy. Unless the person has been determined to be incompetent or otherwise, not able to appoint a healthcare agent, such as someone who has a guardian. And that's a issue that's a little beyond their scope today, but that's caused some confusion in general. If someone has a guardianship, you really should not have that person execute a healthcare proxy without talking to legal counsel, call MHLS to determine whether or not that's appropriate or whether that would become a conflict or more confusing in the future. 2 adult witnesses are required to execute a healthcare proxy. If a person is unable to sign their name, but has the capacity to execute a healthcare proxy, but can't sign their name, a witness can sign their name for them, but has to indicate that the principal willingly executed and free from duress, but they're physically unable to sign, let's say due to some physical impairment that they have. The person who's appointed as the agent, which should be obvious, but they cannot be a witness. There are also special witnessing requirements. If the person is in a facility, either for the developmentally disabled or a psychiatric facility, then there are certain rules about who can witness. And the reason for that is we want to make sure there's no duress, but we also want to make sure that the person has the capacity to actually execute that document. Again, this is a personal right, and it can't be, someone else cannot sign for the person they're a guardian for. There's some articles and standards that talk about healthcare decision-making and capacity issues.
I have to apologize too, Julie. I'm not sure I included Dr. Leiden's article in the materials, but if anyone's interested in seeing it, I'm happy to share it with Erica for wider circulation. But the article's a nice treatment of the issues regarding the factors to consider when determining whether someone has capacity.
And Dr. Lyon in particular used a very, I think he had his own sort of a decision tree he went through when talking about capacity issues. A number of the voluntary agencies use a particular sort of format. There's nothing specific required in the statute of how you determine that capacity. But I know some of the voluntary agencies, either for executing a healthcare proxy, making medical decisions, consenting to sexual activity, have developed their own sort of decision trees and forms that as a way of looking at capacity. There's a healthcare proxy, so you can take a look at. So we have like a couple minutes left, only if we want to get to questions. So if you want to talk about simplified advanced directives or.
I understand Julie's mentioning very limited time. I think we'll just focus on simplified advanced directives for a minute, and we probably, I don't know, so we need to go over supported decision-making. We have slides on supported decision-making. The presentations yesterday were just outstanding and very thoughtful. But I did want to mention the simplified advanced directive because it has been in law, I think, since 2008, that the Department of Health and OPWDD may approve and authorize the use of what was called a simplified advanced directive. But for the statute to be effective, it was dependent upon a form being developed, and that form has never been developed. OPWDD had formed a work group after the enactment of the chapter amendment to the mental hygiene law. I recall being on the work group with any number of people. We came up with a product that resembles what is in your material, which is it's called a advanced healthcare directives. There's an informational booklet in your material. This really was the product of this work group and the form that emerged, but it was not approved or has not been approved by the Department of Health or the Commissioner of OPWDD. So this statute has not become effective. But when you think about it, and if you study it, it really is a supported decision-making model, because the way this statute should work, the ability of the agent to act becomes effective upon the execution of the advanced directive there doesn't have to be a finding that the person is incapacitated before the agency begins. And some people that use this terminology as an act now healthcare proxy, but I also view this as really another supported decision-making model where the principal and agent can support, healthcare decision-making. So I would like to see the development of reform. I think it would advance the law. I don't know whether we will see it. It may not be as much of a priority for OPWDB now that they are, really working on supported decision-making, but it's in your materials. And the only other thing I wanted to say before we open up to questions, and I wanted to say that over time, any number of us at MHLS have worked with your guardianship committees around healthcare decision-making. And I think Patricia said this yesterday, but I really view your corporate guardian program as another example of a supported decision-making model in practice. And I have found that I feel your corporate guardian program really does fulfill your fiduciary duties and responsibilities by honoring the wishes and preferences and capacity of the people that you're serving. And so again, when we think about the evolving legal landscape and we think about supported as opposed to surrogate decision-making, there's a distinction, but I have really always felt that your corporate guardianship program was operating as a supported decision-making, really a supported decision-making program. So
I want to hit three quick things because I've seen some questions in the chat, and then if we, in our last 5 minutes, if there's any sort of pressing questions. So Sheila mentioned sort of an act now healthcare proxy. Something important to know about a healthcare proxy is a healthcare proxy only goes into effect when the principal lacks capacity. And I gave you the example about my husband making decisions for me. But it's also the case that someone could have a capacity to sign a healthcare proxy. Someone could say, I want my sister to make my decisions for me. I trust her. I care about her. I want her to make decisions for me. And yet they could that very day be presented with a complex decision-making for which they lack capacity, such as, for example, deciding between different types of cancer treatment. So a person may have the capacity in order to execute the document, but it might be determined by a professional that they don't have the ability to choose between competing treatments, let's say for cancer, or end-of-life decision-making, which is my second point. And again, that would be a whole day in and of itself. But just so people know, because it comes up a lot, we get a lot of questions about this, even if there is a guardianship in place, there is still a statute in New York which has certain requirements for end-of-life decision-making for individuals with developmental disabilities. So we get, I'm the guardian, why do we have to give notice to MHLS? And again, these are things that were put in place due to a history of undertreatment and overtreatment of clients. And so even if you have a guardianship for a family member, an individual, still have to follow the procedures for proper notice for end-of-life decision. The third thing is, we didn't talk about powers of attorney. Healthcare proxies are for medical decision-making. Powers of attorney in New York State are for everything else. Sometimes there's overlap because you might be talking about paying or contracting with a medical provider. But again, a power of attorney can only be signed by an individual. They usually require legal advice. They are complex and important documents, but a power of attorney is something that you can use to delegate decision-making authority for your financial affairs, releasing medical records, settling litigation, many other types of decision-making, but access to medical records, but not medical decision-making. So we only have like 5 minutes left because I guess there's a break. And so if our dear moderator has any questions that they want to ask, we're happy to try and address them. And thank you.
thank you very much.
So I'm going to stop sharing.
Thank you. Thank you both. I think this was a fabulous presentation filled with, I've heard these kinds of presentations for many, many years, and I think this was one of the best ones I've heard. And I thank you for all of the information. Let's see if there's any other questions right now that we can ask you, and then if not, cannot cover everything, then we'll get those answered for you. We'll share that with you, Sheila and Julie.
It's such a large topic, so I know we've tried to present a lot of information, so I'm sure there are a lot of questions.
Right. Sarah, do you want to throw out some questions?
Hi, no, I just wanted to note that representative pay is not a slam dunk substitution for a guardianship.
I did see that question in the chat, and representative payee is is really a creation of the Social Security Administration, so that someone who's getting really mainly disability benefits can someone else can be the person who receives those benefits, who manages those benefits. But banks sometimes really don't have an understanding, and they are really very limited. So you may not be able to do certain things as a rep payee that you can do if you're a guardian or if you have a power of attorney. But you will be able to talk to the Social Security Administration, deal with overpayments, receive those benefits and monitor those benefits. And you also may be required to account for how those benefits have been used.
Okay. Can I just ask another question before we finish? If a guardianship, this is from Alicia, if a guardianship was established in another state, but the person currently lives in New York State and has for several years, can they petition for New York to have the guardianship removed? Or do they need to apply for that in the court where it was established?
That's a very interesting question. There is the mental hygiene law was amended a couple of years ago, maybe 6-7 years ago now, that there's a provision of the statute that deals with what they call an interstate guardianship compact. And most of the states, although not all, have signed on to that. And so it provides ways to monitor, to discharge, to modify guardianships from out of state. Sometimes someone has an out-of-state guardianship and it's not being recognized in New York. This has an abbreviated process which looks to, well, what kind of process was the person afforded in the other state, similar. But it also can be used to have a guardianship discharge. What the statute tries to do is say, well, the person's in New York now, how do we get this statute under the jurisdiction of New York? And then there are different things that can be done, such as discharge modification. Now, if you go back to that other state, will they still consider you under a guardianship? Hard to know, but we can only really be responsible for how that guardianship is going to be treated in New York. And we have actually used that statute in a number of situations to either have a guardianship modified or to have a guardianship sort of confirmed in New York.
So Julie, thank you for that response. So where do people go? Where does a family go or an agency go if somebody is arriving in this state or moving to another state? What is the process?
Well, at some point, someone's going to have to make an application to the court. So they probably need a lawyer to be able to do that for them. It can be a little hard to navigate without an attorney. So they can, they could contact local MHLS maybe for some information. I'm not promising there would be representation because again, we don't usually represent petitioners. But they can start there. They can contact the local bar association to find attorneys who do really guardianship work or elder law. But they probably would need a guardian. I mean, they could certainly contact a court on their own pro se, but they can't get legal advice from the court, and it might be difficult to determine what they need to file.
Okay, thank you so much, and thank you everyone. This was great, and I know that we can come up with more questions, but we'll share them with you, and then we'll hopefully be able to provide some information even on our website in terms of some of the responses. So thank you again. We have a 10-minute break, and then we're going to start our very last session, and that's going to start at 10:40. So we will see you back. Take a break, and we'll see you soon.
Thank you.
Thank you.
Bye,
Thank you
bye,
again.
everybody. Thanks for inviting us.
Thank you. Take good care.